Good evening, everybody, and welcome to this edition of True Crime with the Sarge. I'm your host, Joseph Giacalone. And out of Canton today is prosecutor Hank Brennan on the ropes. So we're going to find out a little bit more today. A lot of stuff going on with us today. Joshua Ritter, Esquire, lawyer, also the host of Courtroom Confidential. All his links will be shared in the chat under Nightbot. Nightbot gets a little frisky out there, so we'll see exactly what happens. Josh, welcome to the show. Thanks for coming on.
Thank you so much for having me, Joe. I've been looking forward to this.
Yeah, this is, I've been looking forward to it too. I mean, a lot of stuff happening today. We're going to get into some of these things and we'll try not to get into some of the weeds, but I can tell you, I think there's, between the doctor talking and then, of course, the Sergeant Barros thing. I want to start off with the Sergeant Barros thing.
Yeah.
Uh, it started off as it was going to be a grand slam, and then the cross examination kind of took it down a few notches. But let's get into this. What Because I think sometimes people fail to realize that the defense doesn't actually have to prove anything. Correct?
Yeah. Oh, yeah, 100%. Yeah, that's a really good point that is often missed. This isn't like a civil trial where both sides are trying to prove something. The defense could sit on their hands through the whole trial and do nothing. It's the burden is on the prosecution the whole time. We all know that. Where they start to get into a little bit of trouble is when they start offering alternative theories, right? Is when they start saying, well, the prosecution hasn't proven X, Y, and Z. That's one thing. But when they start to, and in fact, what happened is A, B, and C, and they start to promote their own kind of theory, I think they open themselves up for some questioning and some not a, but like the idea of their theory being put to the test, right? But that doesn't mean that the burden has shifted at all. The burden is still on the prosecution. So if the defense raises some theory, those wounds come from a dog bite, not from a vehicle collision. Just because the defense may not have proven a dog bite beyond a reasonable doubt, and I'm not saying that took place or not, but just because they haven't doesn't mean, therefore, the prosecution wins. The prosecution still has the burden. It's just the defense is allowed to present alternative theories and raise questions. And if some of those hit and some of those miss, doesn't really matter. Their whole job is just to call into question the prosecution's case.
Right. So when you had Sergeant Barros on the stand today, he actually, what originally I said that he sunk the Commonwealth's battleship with his testimony about that taillight, right?
Yeah.
But then we had the recross, or no, we had the cross. Explain to us that whole situation. So the defense calls up, does his, I mean, excuse me, the prosecutor does his thing, and then the defense comes in. Explain that whole process to us about how that went down today.
So I agree with you. I thought Barros, and he was a good witness for them in the first trial, and they were trying to kind of recreate some of that magic this time around by calling them in their case. In the first trial, I think they had more of an impact because it was a witness called by the Commonwealth. So they're taking the Commonwealth's witness on cross-examination and pointing out these issues with the taillight, right? Which is highly impactful when it's coming through the Commonwealth's case. This time around, Brennan, who I think has been very smart, I think he's been very streamlined in his approach. I mean, he called about half as many witnesses this time around. He didn't call Barros. So now the defense, if they want that issue brought up, the idea of whether or not this taillight, how many pieces were missing before or after it made it to the Sally Port, which is a big point for them, they're going to have to call him. So they called him. I thought he did a very serviceable job during direct. And then Brennan gets up on cross-examination. I know that there are not a lot of Brennan fans watching right now. And I get it. I think he's got a way about him and a delivery that can kind of rub some people the wrong way. But I think that you have to be honest and say the guy is a very skilled attorney and he's a very skilled cross-examiner. And he did, I think, make some inroads into having that officer call into question his own memory about some things and just kind of say, I'm not writing down specifically in my report in great detail what I noticed. I am going off of my memory. My memory, like anybody's memory, has faded over time, and got him to admit some things regarding his own memory. And then there was the whole the whole issue about that you met with the defense at the defense hotel in their conference room and that whole issue and everything. But then I'll tell you this, Alan Jackson is just as skilled, if not a better attorney, trial attorney. And he got up and in redirect, I think, made some excellent points about who gives a crap. You know, if you can remember every single detail about something, you remember the big points. You remember your birthday took place. You don't remember the day it took place on. I thought that was a really good line of questioning. And then talking about, you know, whether or not they met with him at a hotel, who gives a hoot about any of that. But I think more than anything, what it demonstrated is that you cannot call a witness for a win for either side until you see it all the way through, because they both have been very skilled at kind of changing the direction of a witness through their own examination of them. End of the day, I'll be honest with you, end of the day, I feel like this witness probably did only pushed those who were already leaning in their own direction. Do you know what I mean? If there are jurors on that jury who are already leaning towards the idea that there's reasonable doubt in this case, this probably pushed them further in that direction. But if there were jurors who were not leaning in that direction, it probably solidified their view. I don't think it moved the needle on anyone to hop to the other side. That was my kind of assessment.
Right. But here's my thing, right? So I'm no lawyer. I'm not going to pretend to be one, but I've been around the criminal justice system enough
Yeah.
to understand. And we'll see if I can ask this question. Did Hank Brennan kind of just show all his cards when he went after Barros, right? So he's talking to him like, you didn't document this, you didn't
Yeah.
document that. But meanwhile, I've been yelling from the rooftops this entire case from beginning to end between the Canton Police Department and the Massachusetts State Police. They haven't documented anything. Now, I mean, I know if I'm picking that up, I think Jackson and Alessi, I mean, I think Brennan could find himself in big trouble. You think that's a legitimate statement, or it's a nothing burger?
Oh, I think it's 100% legitimate. If you're Jackson or Alessi sitting through that line of questioning, you were probably, you know, stabbing your pen into your leg to keep yourself from losing it. But you're right. It was a bit rich coming from the prosecutor in a case where there has been so much sloppy investigation to now all of a sudden attack the integrity of a officer who really wasn't involved in the investigation and whether or not he wrote his report accurately or took photos or whatever else. And maybe, you know, maybe Jackson or Alessi or whoever will come back around and make some use of that. And maybe the jurors are, you know, picking up on it just as much as you are and saying, wait a minute, this was the same guy that put up officers who were using solo cups and grocery bags to collect evidence. And you're telling me that this guy didn't do things right. You know, I think end of the day, Brennan's point was kind of like, listen, you were called to testify as to your memory on a very incredibly specific issue. And you did not document that in a way that can be satisfactory that your memory's completely accurate. I think that was his end point.
Right. But here's the thing. Was it really his job to be documenting all that stuff? It's not his case. It's not even his jurisdiction. I mean, it's not. I mean, this is where I think Brennan kind of might have pigeonholed himself into this thing. Because like I said, I'd be bringing it up for sure and saying, you know, guys. And then we're also, I want to get into too, but I mean, there's a parallel into this too. So he was okay with this officer Dever like having false memories and not being able to remember certain things like that. That wasn't an issue. But this guy not remembering something, oh boy, right? But I want to get back into with Barros. I picked up on something that I've actually fell in I think my first time I ever testified. This rapid fire questions, and I think he got Barros because he was asking those questions, boom, 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 and I'm yelling at the screen, going, slow him down, because Barros makes a big mistake by answering a question like basically not knowing the answer and then getting himself embarrassed.
It did seem like Barros at one point, I'm not saying he surrendered, but at one point you could tell he was kind of fatiguing under the cross-examination. And he did seem to kind of allow Brennan to lead him by the hand through some of that rapid fire questioning, and maybe should have done something to disturb his rhythm a little bit, should have slowed it all down. I'll be honest. Another way, though, I think you can look at Barros is that I felt him to be honest. And
Mhm.
sometimes honesty means admitting things that are not entirely favorable to the side that you're testifying for. And in fact, in this case, having testified as an officer, he's not employed by the defense. He's not an investigator of the defense. You would expect him to be admitting to things that are not always entirely beneficial to the defense. I think that jurors sometimes pick up on that and might believe, okay, this guy's a straight shooter, though. Yeah, he's
Mhm.
admitting his memory may not be completely without flaw, but that's a straight shooter answer. I would much rather have my witness say that than to say, no, my memory today is as perfect, if not better, than it was 2 years ago. That's just an unbelievable statement to make, and I think that maybe that's how the jurors might view it.
Right. Yeah. No. I mean, I could go downstairs and then forget why I'm there. So, so I mean, I think we've all been there. Once you hit a
Yeah.
certain age, things could get that way. But yeah, I think I just want to take a quick shout out the offloaders. Thank you very much for that super sticker, and also Chihuahua Mama for becoming a member of the channel. Thank you very much. Yeah. No, I think that the jury, first of all, can't unhear what he originally said about this whole thing, and I don't think Brennan totally dismissed it either. And I think that becomes an issue, or at least an overhang. And I kind of agree what you said there, right? Maybe push the needle a little bit either way. Nothing. It looked like it was going to be a home run, and it ended up
Yeah.
being a single, right? But
Yeah, I don't think it was a home run for either side. I think that the defense was probably hoping for more out of his testimony than what they got. But again, I think that maybe is more of a function of how it was presented. When, it's one thing when you have the Commonwealth's witness on cross admitting to certain things, and it almost makes it like this surprise moment and surprise revelation that that's coming through the opposition's witness. It's another thing, and probably going to just be by its nature less impactful, that it's coming from their own witness. They're calling him for the sole purpose of saying this thing, and I don't think it delivered the impact that they might have been hoping for. But that doesn't mean it was not helpful at all. I mean, he still is, end of the day, still is saying, hey, in my memory, there was less damage to that light before it got to the Sally port. I mean, that's just his memory of it.
right, and then if they can tie this into what Officer Dever was originally saying about people being in the Sally port and everything else, I mean, that could make a lot more sense. But that is all kind of off the table too. Okay, procedural wise, correct me if I'm wrong. So we had the cross.
Mm.
And then don't we get a recross, right? So Jackson gets the recross, and
Mm-hmm.
then the prosecution says something, but there's no. You will have to do a recourse.
There's no rules on that. The only rules on it are up to the court, up to the judge. I think what Canoni was doing there was she was making sure that either through redirect or recross, they weren't getting to other topics. And that's the way it should work. So your redirect should only address things that were brought up in the cross. You're not allowed to then, through your redirect, open up the door to a bunch of other stuff that wasn't covered before. It's only supposed to be addressing cross. And then the same way should work for recross. And I think what happened is at the end there, she felt like, listen, you guys have hammered the same issue from both sides so many times. I'm just ending it here. Could she have given Jackson the last word? Maybe. Would that have changed things all dramatically? Perhaps not. I think she was just kind of like, listen, you've both hammered your points. We've addressed everything on this. We're ending it.
Did Brennan though kind of repeat basically what he said though the first time around? I mean, was it really a cross examination, right? Kind of.
You're talking about on his recross?
Yeah, and the recross. It was like
Yeah,
the
I mean,
same thing.
his whole point was your memory's not great, okay? And then I'll be honest with you, I got a little lost on the pictures he was showing them, because sometimes we could see what he was showing them in court and sometimes we couldn't. But it seemed like he was trying to make an issue about perhaps what they were looking at was snow on the car. Am I getting that right? I felt like he was
Yeah.
trying to make an issue about maybe what we're looking at isn't damage as much as it's snow. And I'll be honest, that got a little lost on me as to what the point was he was exactly trying to make. But end of the day, I think what he's trying to say is like, listen, if we're hinging this entire case on your testimony, that's not a great hinge.
Yeah, no, but I mean, even the pictures that they show of this thing, I mean, if that was me, I'd be like, I can't tell anything from that
Yeah.
picture.
Yeah.
I mean, it's
No.
snowing, the snow is
Which
coming down.
goes back to your original point. Why don't we have a bunch of fantastic pictures from the scene? Right? Why are we well, I mean, I guess some of that makes sense in that the car wasn't in its original location and everything else. So I can't entirely throw the prosecution under the bus for that. But it did seem like in a case where the tail light and everything else is going to be so important, you would hope for better pictures than what we're dealing with.
Yeah, no, I mean, it's like it's. I always say, I always make a joke. I go, you get these pictures from Mars, everything looks great, and then the bodega on the corner, it looks like it's in a pixelated movie, for crying out loud. I mean, it's unbelievable exactly
Yeah.
what you can get on the video cameras. But listen, documentation, documentation,
Yeah.
documentation, and it didn't happen in this case. And I've been screaming about this from the first trial. From that first officer on the scene.
I got a question for you. Do
Mhm.
you think that when they first rolled out, there was not in their heads the idea that this was going to turn into a homicide investigation? In other words, they treated it like a vehicle. I think they always thought it to be a vehicle on pedestrian impact, but that they didn't conduct their investigation as carefully, thoroughly as they would have if they thought it was a homicide investigation from the jump.
Right. They broke the golden rule of death investigations. Treat every case as if it's a homicide until proven otherwise.
Yeah,
That is the plan. And that means separating your witnesses, which didn't
yeah,
happen, which means putting up crime scene tape, which didn't happen, which means keeping people out of your crime scene, which didn't happen. I mean, and then I think they left the crime scene unattended for a while to boot.
yeah, yeah,
So, I mean, you broke every rule, and then of course nothing's documented. There's no photographs. There's no nothing. And I've been saying too, why didn't they wait till the daytime? Keep everything as is. Wait till the daytime, and then you know what, Josh? No one is ever going to convince me a good reason why a canvas was never done. Knocking on
yeah,
people's doors.
yeah,
You have a dead individual on somebody's front lawn, and you don't knock on the door. I mean,
yeah. That's such a great point that it was. That's what I've always thought, is that they didn't really feel this was going to become issues down the road. And now they tried to play catch up, and they tried to play catch up far too late. And it's
you
coming
can't.
back to
Yeah.
haunt them.
I tell my students too when I do this. This isn't a playground. You don't get a chance to say do over and start over
Yeah.
again.
Yeah.
Once it's gone, it's gone, and then you
Yeah.
open up the door to exactly the mess that we've actually seen in this case from day one. And also too, I thought there was overcharging to begin with. I murder
I,
for this
I,
was
I
to
I
me, I think.
agree with you on that. I have always felt that the weakest part of this case for the Commonwealth is not, and I know people's heads are going to explode, it is not
Uh-oh.
the not the vehicle impact, it's the intent issue. Like,
Yeah.
it's one thing, we're all sitting here going back and forth on car this and taillight fragments that and dog bites this and everything else. End of the day, that's one part of what they have to prove here. After they prove that he was even impacted by a vehicle, then they got to improve some sort of criminal intent behind it. And to me, that's the weakest part of this case. And it goes to your point about it being overcharged. I've always felt it's overcharged.
Can you explain to the audience too? Because I think there's some confusion. The difference between, or if there's a difference between voir dire, and deposition or deposing.
Yeah. Um, so, okay. So you have, and it depends, each jurisdiction uses these things differently. So you have like police interviews, right? Which you are very, very familiar with. Police interviews, and you sit down and you interrogate someone, and that's all being recorded. That's one kind of prior statement that can be introduced. Depositions are in some jurisdictions used in a criminal case, but in most they're used in a civil case, but that is under oath testimony. So now you've got a person sworn, taking testimony under oath. It's being transcribed, and both sides have an opportunity to question someone, and that testimony can be introduced in court in certain circumstances. A judge is not present, but it's treated the same way as if it were court testimony. Then you have voir dire, which is where usually the situation is you're in court, you're outside of the presence of the jury, and for some sort of foundational issue, you want to question this witness to establish whether or not are they qualified to testify to a certain level of expertise. Do they have a foundational understanding of an issue that we might be raising during cross-examination or during their examination in front of the jury? And you don't want to do that in front of the jury for any number of reasons. All of these, though, are just different types of kind of prior statements that can then be used later on to impeach that person or refresh their memory and everything else. It's just different ways of people testifying.
Great. Yeah, I just want to make sure that everybody's listening because I do these quiz questions, so
Yeah,
you know that's coming out. But
it's coming up.
Josh, Josh, I have to thank you, and Tiffany probably on the other end there
Oh, yeah.
for those 5 memberships. Thank you very much. That was really nice of you. And one love with these super sticker. Thank you very much. You guys are very generous. Thank you. So let's. I mean, I thought today I didn't expect the craziness that comes out of today. I do want to talk about Dr. Russell
Yeah.
just a little bit. So. And I think the biggest thing here, and actually Sheila Duffy asked a question in the chat, and I was one of the things we wanted to talk about. Alessi came out with his big speech today about the DNA being brought up and asked for, once again, a mistrial with prejudice.
Yeah.
What is a mistrial with prejudice? And I want to talk about the whole, I guess it was like, I'm not going to call it an act, right? But a performance. Let's put it that way. It was very performative. So let's first of all, let's tell us what a mistrial with prejudice means.
Yeah, I love it because he he was so great. He came up there with no notes, and it's just, he was almost white knuckling the podium, and he says, "I strongly and vigorously request a mistrial with prejudice," and it was just like one of these moments. Yeah. Yeah, I think a lot of that was performative. I always love when attorneys say, vigorously and strongly, which makes me think, well, when you're requesting these otherwise, is it just kind of like you're mailing it in? So this is somehow different, But so with prejudice means end of the case. Like he was asking the judge declare a mistrial that they will never then be able to bring this case again. In other words, I don't want you to declare a mistrial and we're going to go back and do this trial again. I think that the error that has taken place is so fundamental that you should end it here and now. You remember in the Alec Baldwin case, there was a prosecutorial misconduct issue brought up, and the judge dismissed that case, declared a mistrial with prejudice, dismissed it with prejudice, which was why the prosecution was never able to bring him to trial again. So that's what meaning with prejudgment, with prejudice. So meaning it's done. What that was all about, though, was during the cross of Dr. Russell, and this is something that's totally allowed. The prosecution, Brennan, was getting into all of the things, other factors that she may or may not have considered in arriving at her opinion, which is just kind of cross-examination of an expert 101, right? So it's like she's up there saying these are dog bites, and he's allowed to say things like, okay, well, did you consider the debris field? Did you consider the trace evidence on his person? Did you consider all of these other things? And then he threw in there, did you consider whether or not canine DNA was recovered off of him? And the defense lost their minds because that was never brought in during the prosecution's case in chief. And so really what it was an issue of facts, not in evidence. They're saying he is now introducing facts that have not been proven through his questioning of this witness, and the jury doesn't know what he's talking about. And now he's getting this evidence in front of the jury through a question, which is all improper. And to some extent, they are correct. You are, however, allowed to cross-examine an expert with things that are not admissible. You can cross-examine an expert. They're allowed to consider things like that are hearsay, things that are otherwise inadmissible. So you're allowed to cross-examine them on that. And Brennan's point, and I think it was correct, and I think the judge ruled correctly on this. And again, don't sharpen your pitchforks for me, but the idea was that, listen, as the prosecution, I don't have to preemptively confront the defense case. In other words, I presented my case straightforward. This was a vehicle on person collision. If they want to introduce dog bites, let them do that. But I don't need to bring up in my case in chief that this was not a dog bite and preemptively confront their arguments that they may or may not make. He's saying now they've made it. Now they've called a witness, and this witness is bringing up for the first time the issue of dog bites, and I'm allowed to confront that witness with things she did not consider. Now, what the judge, I thought, was going to say or should have said is that in order for him to complete that impeachment, he has to then call an expert about the DNA, about the lack of canine DNA. So I imagine now he will in his rebuttal case, but he did not need to do that preemptively just to ask her those questions. That's where that was all coming from. I hope that
Is
wasn't
that
too
yeah?
long-winded.
No, but does that open up any door though for the benefit of the defense? I mean, because there's no dog bite expert, right? There's no DNA dog expert. I mean, does that have to
I
be?
think the prosecution, well, it does if they don't call somebody in rebuttal. If the Commonwealth does not call an expert to say that there was no canine DNA found on John O'Keefe, then that does create problems. Now you are talking about he asked questions based on things that have never been introduced. But if he completes his impeachment by calling that witness, then it shouldn't really be a problem.
Just want to give a shout out to Farm Girl. Thank you very much for that super sticker, and also to Lisa Mitchell. Thank you very much, Lisa. Uh, Acute grief reaction. The
Yeah.
doctor. Yeah,
Yeah.
let's talk about that. I thought that was actually pretty interesting because from the defense point, because right, the defense is going to try to get, did I hit him? Did I hit him? Did I hit him? Which, well, by the way, was never documented uh by anybody. But I thought that was actually a pretty good move on the part of, I guess, Dr. Russell, but I don't know if it was pre-planned with the defense.
I don't know if it was pre-planned either. And if it was, then applause to them, because that was definitely playing some 3D chess. But I really felt like that was one spot where Brennan, I thought his first of all, I feel his cross-examination of her was really good. I also feel she was a remarkably good witness. I think that you just saw, a really good witness up against a really good attorney, and that's how these things play out. But he kind of waded into this, and I think he stepped in it, not realizing it, because she took that layup and really drove it home. And yeah, her point was like, this was again a part of the stuff about, did you consider other things? Did you consider statements that she made? And I don't know if he realized she was going to go back to the statements of I hit him, I hit him, I hit him. And she did. And then she said, I've seen this all the time, which I thought this was incredibly powerful. I've got
Yes.
people in my emergency room all the time taking credit for things they don't need to take credit for. And, these incredible assumptions of guilt that they don't need to take credit for. I thought that was really good and really powerful. And I'm sure the defense was just loving every second of that, because it was probably the best explanation for why those words may have come out of Karen Reed's mouth, if in fact they did. But to his credit, I thought that Brennan's then follow-ups to that were also fairly clever too, when he said, okay, well, how long does this immediate onset of grief last? Does it last till 2 years later when you're doing documentaries with Dateline and
Yeah.
the ID network and sitting down? Like, I thought that was also a
Yeah.
pretty clever rebuttal to that.
Brennan has been really good on
Mm.
his, think about it. And I mean, it's amazing because I mean, like I said, I used to do some of this stuff too. The the quickness that this defense attorney and the prosecutor are using is unbelievable. So the prosecutor,
Yeah.
like I said, it was like it's just like a street fight, right? I mean,
Yeah.
you're going punch for punch here, and and you get off the mat and you hit back, and like I said, Brennan, you got to give him credit because it is just one of those things. Lisa Mitchell, I love your accent. I'm assuming it's mine.
What?
I speak the Kings County English because I was born in Brooklyn. So, but Lisa, thank you very much. I mean, like I said, hate him, love him. He did a great job. Alessi's done a great job, and so has Alan Jackson.
I really think that we are getting a treat just from a kind of spectator's perspective. And listen, a man lost his life. I'm not trying to make this into some sort of spectator sport. I want to drive home that point that it's, we should not forget John O'Keefe's and his family. But from a perspective of just watching incredible trial advocacy, you could not do any better than this. I mean, you've got really tremendous lawyers on both sides. And I know a lot of people have picked their sides and feel that, their side's doing great and the other side's doing horrible. I think both sides are really doing a very incredible job. And you're right. They're very bright. They're very quick. They think on their feet. They never seem to be caught. I can't think of a moment where I feel like one of them was really caught on their heels. And if they were, it was only for a flash before they rebounded and found another clever way to ask a question to get out of it. And I think you saw that on full display today.
Yeah, absolutely. I was going to say today with the Barros thing, he came, Brennan came pretty good. I still think, in my own opinion, I still think that the Barros thing weighs a little bit heavier in regards to this because the jury can't unhear these things.
Correct.
And even though he was talking about the memory thing, listen, let's talk about memory issues, right? Like Officer Dever yesterday. I don't think I've ever seen something like this. I created a false memory, I think was the actual quote, meaning that if I'm wrong, somebody put me in. I think that's accurate. I think that's exactly what she said, but I don't know how this sits with the jury. I really don't.
I think that, well, first of all, there was no question that she was not happy being there. And there's no love lost between her and Alan Jackson. Oh, and Gisela. Hey, Gisela.
Midnight, just after midnight. Jeez, thank you, Gisela, for showing up here.
I have a theory that Gisela actually doesn't ever really sleep. I think she just kind of recharges quickly and then gets back after it. But I think that she was obviously very confrontational and snarky, and there was a lot of kind of pissing back and forth between her and Jackson. Yeah. I think that the way that she the way I understood what she was saying was, listen, I told investigators one thing. Then I was presented with evidence that showed the thing that I told them could not be true. And so therefore I am now saying that what I had told them is not true. I misremembered or I misunderstood what took place that day. But the way it came out through her testimony was, I created a false memory. Well, that's a really awful way of explaining that. That sounds like you're making things up or you're lying. I think at one point she was even saying that, yeah, that was a lie. I mean, that's just awful stuff for a investigator to be saying. That all being said, she, again, I don't think was as much of the home run that the defense was hoping for, because then there was all this stuff about you threatened me with perjury if I didn't come up here and say the exact same thing again. Now that to me was like, holy crap, is this really happening? And then it just kind of all went to, chaos after that. But yeah, she was a spark plug of a witness.
Yeah, no, I think she has a difficult time going forward though for any trials or any cases, because now let me ask you a quick question. If you had a trial with her recently and your client was found not guilty, would you be looking for a review after she just got done saying she made up a false narrative? Would that be something?
I think she probably will have this entered into her Brady file. I think so. I mean, I think something like telling investigators one thing and then later admitting either that you were wrong or, at the very best you were misremembered, and at the very worst you were just giving them false information. I can't see how that doesn't end up in a Brady file. This is gonna probably haunt her for some time.
Right. Well, since you brought it up, right? So what is this Brady list all about? Let's define that. Get your pens out, everybody. Write this down. What is a Brady list?
So every agency, and it's become much more formal than it was decades ago when you and I were still in law enforcement, but now they're very strict about this. I know here, certainly in Los Angeles, there's an entire Brady unit whose whole job in the DA's office is to keep track of essentially police misconduct. And it's not just all misconduct, but it's allegations of misconduct. It's allegations of dishonesty. Anytime there's something like that done, it's put into a file regarding that officer. And when that officer is a testifying officer in a trial, that has to be turned over to the defense. Now, just because it's turned over doesn't mean it's all used. Each judge will have to decide, is this applicable to the case that we're talking about here? But the defense, because of this case of Brady, meaning Brady stands for the idea that all evidence, exculpatory or inculpatory, has to be turned over to the defense, and that includes anything that calls into question the veracity of a police officer. So they have to turn this stuff over, and then in each case, they're going to have to decide whether or not that becomes an issue. So like this officer, Dever, or DeVere, depending, I guess, on who you are.
God. Yeah, it depends on how angry she got at too, which was ridiculous.
Dever will probably, I'm guessing, have this in her file, and if she goes to testify at other trials, they're going to be made aware that this was an issue in a previous trial, and then it will be up to the judge in that trial to decide whether or not the defense can get into it with her. But you're right. If she's testified in other cases, there are probably attorneys looking for, to raise that issue.
Yeah,
I don't think it went as far as finding that she perjured herself, but it was not a good look.
Right. Yeah, no, I'm not saying she lied or perjured herself exactly, but when you come on the stand and say I created a false narrative or false memory.
False memory. Such an awful way of putting it.
Yeah,
awful way of putting it.
How about just say, how about this? I made a mistake. I thought I saw something. I worked 18 hours in a row. I was on overtime. I worked through the night. I was tired. I thought right? Wouldn't that have been a much better answer?
100%. I told the agents what I believed to be the truth at the time. They showed me some stuff that showed that couldn't have been true, and I realized my error and admitted it immediately. I mean, there's 10,000 different ways you could have done it better than the way she did it on the stand. Yeah.
If it was me, I would have said, listen, I worked 18 hours. We had this big, death investigation going on. I got from patrol. I went into the dispatch, which, and answering the questions about the surveillance cameras. I mean, good grief. I mean, it was like pulling teeth.
Yeah. There was no, like I said, and again, that goes to, I think, really, which way are the jurors leaning? I mean, I could see jurors watching her and going, well, this person isn't trying to be honest at all. They're just absolutely fighting with the defense every step of the way. Or I could see people saying, well, listen, this person feels like they're put in this position by the defense, and the defense is trying to get her to testify to things, and she's not on board with that. I don't know. If you ask me to kind of call that witness, I would say it probably was a net benefit to the defense more than it was to the Commonwealth.
Yeah, no, I mean, in the whole issue of she doesn't have a lot of time on the job. I had my buddy Mike. We did Mike had over 30 years in, and I had over 20 in. And I asked him how many times he's been to the police commissioner in his 30 years. And I had my 20 years, and we both come up with 2, I think it was.
Yeah, right.
But I was involved in a shooting. I went to go see the police commissioner, and then I got promoted the second time I see the police commissioner. Other than that, I thought that that's a bad look, right? It's a bad look. Is there a possibility that they call the Boston police commissioner into this to find and ask him what did he say, or that's just too much of a gamble? Because he's just going to say, I didn't say anything, or I'm going to say.
I think that's way too much of a gamble. I think they insinuated enough of made enough of an insinuation, and they should leave it rest. The last thing you want to do is have some commissioner up there, and going sideways on you when you don't know what he's going to say.
Yeah, because she actually went sideways on them already. But I just think the perception on this one is going to be sticking with the jury, right? The jury is going to perceive that there was some sort of shenanigans that happened. Like, why was she called into the police commissioner's office to talk about this and then say, do the right thing? And I tell you, you always tell the truth when you're on the, so when she's like, oh, I have to tell the truth today. No, you have to tell the truth every day you're in the
Mm,
court.
mhm.
And she also, where they made a big deal out of it, and I think they should have, was the fact that when she said, my job depends on what I say here today.
Yeah.
Yeah, no
Yeah.
kidding.
Yeah, and Alan jumped on that immediately. Yeah,
I would too. Yeah, that was a hanging curveball.
what did you think though about her saying, "You guys told me if I didn't testify how you wanted, you would try to charge me with perjury." Do you think that how did that come across to you?
Well, I mean, me knowing that they couldn't do that, I'd be like, I got two words for you. They're not happy birthday. So that's the first thing. Y- Uh, but yes, and I would have said, okay, you know what? Then charge me with perjury. Go ahead.
Yeah.
But I mean,
Yeah.
at this point, it was a moot thing. But Jackson doesn't deny it, nor does he even say that. He doesn't deny that they said that they were going to charge you with perjury. Um, but he only thing would say is, have you ever seen a defense attorney charge somebody with it? Who charges it? And she couldn't even answer that question.
No, I'm also wondering, like, they had this conversation with her beforehand, and it must have been abundantly clear in that conversation that she was not going to be friendly to them on the stand. But they still wanted that piece of information out of her, this idea that she had seen the two of them in the Sally Port
Mhm.
for a long period of time. I kept on wondering, like, was the juice really worth the squeeze in all of this? Like, with as much kind of garbage that she threw at them, with this idea of them trying to tell her she's got to say one thing even if she doesn't believe that to be the truth, was it really worth that little piece of information she gave them? I don't know. They felt that it was. I feel like, I'll put it to you this way. If they had it to do over again, do you think they'd call her?
Probably not.
That's what I mean. So I think end of the day, they probably are looking at that one like, okay, some you win, some you lose. Let's move on from this one.
But let me ask you a question. Do we know how they even found out about the meeting between her and the PC? Has that ever come out yet? Did I miss it?
Um, I don't know if that did come out. I think
Because I'm like, boy, that's a light bulb moment.
yeah,
If they
I don't know how they said that came out. That's a good question. I don't know. I don't
did
know if that was
somebody in the
turned
inside
over.
leak that out, is the thing. I
Maybe,
mean, that's what it would have to
maybe.
be.
I don't
Yeah,
know. Yeah. Or
that
maybe
would
they
be.
received, it seems like they knew about emails. Maybe they received emails from her, communications between her and about this case or something as part of a discovery. I don't know.
Well, she also did two things that Judge Canoni said she didn't want done. Right? She kept on bringing up, I wasn't part of the first trial, wasn't part of the first trial, and then
Right.
she brought up the three letters that the judge
Right.
said you
That
cannot
shall
bring
not be
in.
spoken. Right.
Right. The FBI. I mean, so listen, that cat's out of the bag officially. That because it's been rumored that the FBI has been involved in investigation. Well, that's no longer a rumor.
Yeah.
And do you
Go
think?
ahead.
Do you think her thing? Well, I called the FBI and told them what I did, and they seem to be okay with it. Yes, it was no problem. I don't know
Yeah.
about that.
I'm curious because we have to assume that the jurors don't know about the federal investigation, right? I hope that they don't. I mean, they've tried to pick good jurors who don't know much about this case. So let's assume that the jurors don't know. I'm trying to imagine, what are the jurors doing with that information? When she said, I called the FBI, are they somehow then realizing that it was the FBI that had interviewed her? Or are they just thinking that she called the FBI because she felt like she was threatened by a lawyer? I don't know. I'm curious as to how
Or,
that lands with the jurors
or the third option is, why is the FBI investigating this
at
case?
all, right?
Right.
Why is she ever even thinking of the FBI? I don't know. I don't know if it I don't know.
I
It
think
was
that
it
let a big cat out of the bag, and I think that if anything, that the defense gets out of this is that the jury knows now something really terrible happened the first time around, that even the FBI is involved in this, and there's a whole bunch of shenanigans going on between the police commissioner of Boston and this cop that came from Canton to Boston PD. I think that was the ultimate goal, but I still don't think they bring her back if they had a choice to do it again.
I also don't think that the jurors are as dim-witted as we might think they are. Like when you're talking about, and weren't you contacted by in agents of another law enforcement agency? Like I think they're starting to put together that something bigger was going on behind the scenes. It's just a matter of what do they think that was?
Well, she corrected him, right? Because he said 2 police officers, and she goes, "I don't think they're police officers."
Yeah. She brought it up. I don't think they were cops.
Like I said,
Yeah.
she kept on bringing it up, and I'm sure the judge was having a mini stroke on there because
Yeah.
this is something. Hippie Mimi, thank you very much for becoming a member, and Tina for gifting 5 memberships. Thank you very much, Tina. Yeah. So, and here's the other problem, and I kind of mentioned it before. The prosecution was worried about the memory of Sergeant Barros, but apparently was not worried about the memory of Officer Dever. So, I mean, does the defense bring that up, do you think?
Yeah, but I think they're going to have to wait till closing. I don't know of another way that they can make that point. I think it's an excellent point to be made for closing arguments. But yeah, I can't think of another way that they kind of try to revisit that. And honestly, I don't think they should. I mean, I think they've got bigger fish to fry, but I think that they will probably bring up those exact points on closing.
So let's further look at the strategy. So prosecutor Brennan basically denied the defense, and correct me if I'm wrong, Josh. He denied the defense their third party theory by not bringing in the cast of characters that were brought in the first time. You know, the
Yeah,
Galberts and everybody
I
else.
think he made it more difficult for them to do that. I don't think he foreclosed it. I think that they're probably going to try to explore that as much as they can, but he certainly made it more difficult for them. I do not understand the strategy that Lally used the first time around, and I'm not trying to play the whole throw Lally under the bus thing, but I
I'll
do
do it
not
for you.
understand calling anybody and everybody who happened to have been in a 1 square mile radius of the house to the stand. I think that Brennan has done a remarkable job of streamlining this whole thing and just being like, I'm putting on the witnesses that move the ball. These are all witnesses that move the ball forward. And if you, the defense, want to get into Proctor and Higgins and Albert and everybody else, go ahead and have at it. But you're doing that in your case where I can cross-examine them, and we'll see who they cut. Sounds like they're calling nobody though. Of those central figures, I don't think they plan on calling anybody.
Well, I think they would, after we witnessed Brennan do his cross examination. I'll tell you, if they bring somebody in, they better be prepared, because this
Yeah.
guy is on his game. But
And I tell you, the
Okay.
funnest thing in the world, sorry to interrupt you.
No worries.
The funnest thing in the world is to cross-examine a witness friendly to you, by the way. Like that is just easy sailing for Brennan to, if they were to call somebody like Higgins to the stand and Brennan gets to cross-examine him, you just have a field day when it's a witness favorable to you that you are quote unquote cross-examining. But sorry to interrupt. Go ahead.
No worries. Before I say that, before we get to Joy's question, we have a little bit of a third party theory already tested, right? So we have Dr. Russell talking about the dog bite. We
Yeah.
had Officer Dever refer to Chief Berkowitz, who is no longer alive, and Higgins, the ATF agent, who has an office there. So they were in the room for a wildly amount of time, right? That
Right.
whole thing. So they're getting it. How do they get their third party story into this? Especially if they don't call anybody that's involved in it. How
Yeah.
do they do
Well,
it?
so they've got Proctor's text messages in. They've got the dog bite in. They've got the idea now that there may have been some shenanigans taking place with the tail light, that it was in the Sally port, and then all of a sudden the damage to the tail light looks to be different. And I think they just argue that stuff. Again, it's just kind of the function of the way this trial has been put on that it's made them much. I mean, by the time we were at the end of the Commonwealth's case in the first trial, I feel like you knew all of this stuff already because of through cross-examination of all these people. But now, without having heard the cross-examination of all those people, I think they're going to have to really connect all these dots for the jurors in closing, because they're not connected right now. If you try your best to forget everything and just imagine yourself as a juror hearing this for the first time. So you're hearing, okay, maybe there was a guy, inside the Sally port, and okay, there's this other guy that was sending rude text messages, and okay, maybe there's some dog bite stuff, and it's creating questions, but as far as connecting them into this overall theory of a conspiracy, I don't think we're anywhere close to that.
Right. That's what I said. It's going to be difficult. I mean, if it depends on who else is on the list. So here, does the defense call Proctor or not?
Well, they've said they're not going to, which is
Right.
surprising to me. I think that I mean, if they're to be believed, the statements they made, they're not going to call him. They've gotten his text messages in already. Maybe they feel like he's a bigger boogeyman to them, unseen than seen. And maybe they realize that they don't want to put this guy up on direct when they're not going to be able to have the same field day with him. And that then Brennan can do a bunch of damage through cross-examination. I mean, remember too, there's this kind of landmine out there as far as things that Proctor may have seen on her phone that he wasn't allowed to testify to, right? And I think they want to avoid that ever becoming an issue, which is going to be a lot more difficult if he's being cross-examined by Brennan. I don't know. I to answer the question, I think they don't call him. I think that's what's ends up happening, which is surprising to me.
So Canone's baloney. That's a question here. Love the collab. Any thoughts on the likely decision on defense's missing witness motion for Proctor Higgins and Brian Albert?
I got to tell you, I'm a little bit at a loss on the missing witness. Is this something that has been filed or they're contemplating filing? I'm not sure on this one. I apologize.
Okay, so Canone's baloney. Can you send us another question, and we'll see if we can get
I know that there was an issue about somebody being unavailable, and if somebody's unavailable as a witness, there are certain ways that you can get their testimony in otherwise, but I'm not sure about. Maybe I'm missing something.
Okay. What do you think it could be the biggest potential trip up for either side going forward in the next few days? Is there a big trip up? Like you said, so if you were doing this case and you were the prosecutor, what would you be worried about, and what would you be worried about as the defense? What do you think? Is there a particular person?
I think ARCA is going to be a big deal. I mean, listen, when was the text message sent? I mean, not the text message, the Google search. How long to die in the snow? When was that made? Yeah, that'll be something. I think that you're probably going to hear their experts say something different, and the jurors again will try to decide between the two who they find to be more credible or not. I think that the dog bite, the prosecution is going to call a dog bite expert to say, no, these are in fact not dog bites. But I really feel that if there's anyone to have the most impact, it's going to be ARCA. And what are they going to do, and how are they going to respond to the witnesses presented by the prosecution? And where I think the prosecution needs to be careful, and I think this happened a little bit with the cross-examination by the defense, quite honestly, is that it's never smart to feel like you're smarter than the expert, right? It's never like these experts have been doing this stuff for decades, and you are a very smart attorney, but you've only been learning this stuff for months. And I think Brennan, if he tries to get up there and act like he's smarter than and knows more about accident reconstruction than the ARCA experts, it could end up backfiring on him. And I think that's where a lot of attorneys make a mistake. It's like, I was telling my wife the other night, it's like if you've taken Spanish 101, don't act like you can cross-examine a native speaker. Okay. Like, just like know your lane, ask the questions where you can, but don't try to speak their language because they're going to chew you up. And I think that he could fall for that. But we'll see. That, to me, that's going to be probably, of the defense case, arguably the most pivotal point is the ARCA experts.
Yeah, the worst thing you could say is "Me llamo Jose," and that's it. It's over after after that. It's over. So here's a little more context. It was filed today. They're stating prosecution should have been called because they're friendly to a complainant witness, and there should be a jury instruction as to what they can infer from that.
It was filed today, so that's why I don't know about it. They're stating the prosecution should have called them because they're friendly to the Commonwealth, and there should be a jury instruction so that they can infer from that. You know what? I got to read into more of it, and I apologize for not knowing enough about it, but I guess the argument being made by the defense is that you cannot play. You have to allow us to treat them, maybe they're saying, as if they're Commonwealth witnesses, and bring them up, assuming that they are hostile witnesses. Maybe that's the argument being made. But, listen, the prosecution can call whoever they want and not call whoever they want. And just because it happens to be causing some trouble for the defense, I don't think there's a jury instruction that allows them to the jury to assume that this is a witness the prosecution should have called. I don't know.
Do you expect any surprises, like from the defense? You think they're gonna try to pull something out of the hat somewhere? And if you did, what would it be?
I still think it's probably going to come down to, there's been so much last minute back and forth between those two experts. You had Welcher practically arriving at decisions the night before he was to testify. And I still think that having heard him testify gives the defense some advantage, that it's now like the prosecution has put on their expert, and now their witnesses are going to be able to respond to that. And there may be some miscalculation. We've seen a lot of issues about the timing of clocks on phones as opposed to in the car, and how this changes the dynamics of everything. And maybe there's some hidden little nugget that the defense has been able to find. I could see that happening. I will say this, though, just to your audience and everybody listening. In my experience, experts do not have as much of an effect on juries as we think that they do. Like, everybody loves to say, oh, this is coming down to a battle of the experts. I think that jurors, and in my experience, they treat them about how we treat them. They find some of their stuff to be maybe credible, some of it to maybe be a little biased. But end of the day, I think they go, I'm kind of making up my mind based on a bunch of other stuff, just because here's a great example. Just because Dr. Russell, who was a great witness and incredibly experienced, just because she goes up there and goes, those are dog bites to me, I don't think that the jurors are going to go, well, that's the end of the case, because they're going to go, okay, well then what about all this debris? And what about all the taillight? And what about the fact that nobody's saying he went inside there's other stuff for them to consider. And I don't think that they're just going to, pick one side's expert over the other. I think I hope at least that they will do a more holistic evaluation of the case.
Yeah, I kind of agree with you on here. Mass Dad saying the name is Barros, not Baron. I thought I said Barros, but okay, Mass Dad, that's fine. Hey, listen, we all got our own over there. Susan is a new member. Thank you, Susan. So, no, I don't know if I expect anything better than today. I thought today was
incredible. Yeah,
today was kind of crazy, and I think tomorrow, we're suiting up thing. But just quickly, we have about a minute left. Tell us about Courtroom Confidential. What are the plans you got going on?
Well, first of all, if everybody wants to see me turn the tables on the Sarge, we interviewed him. That episode is up. We had a really nice conversation. You've got have an incredible career, and I will say that we received some of the best feedback on any of our videos on that video interview that we did with you. So thank you again for doing that. But yeah, check out Courtroom Confidential. We are covering all these cases that you guys are following. We have a episode. We're going to be doing a live tomorrow night, Wednesday night. We're going to be having Gigi from Pretty Lies and Alibis on, and we're going to talk a little bit about Lori Vallow and a bunch of other news going on. And yeah, just, you know, we do Sunday Fun Day. You were in our last Sunday Fun Day. Check this out, where we take questions, voice messages that people leave, and we answer them live on Sunday. So we're trying our best to do a lot of fun stuff over there, and we hope you guys come check us out and subscribe and enjoy it.
Yeah, definitely. I think we're gonna sample some of that question and answer thing. I thought that was a great idea, and I actually was having fun hanging out with you guys doing that stuff. But yeah, maybe we'll do one in the future together too.
Yeah,
we can do a
fun.
half law enforcement question and answer stuff. But Best Nancy says the Courtroom Confidential crew is here. Josh, I want to thank you. That hour went by so fast.
Yeah,
but it was actually very good, and I don't know how many hate mails we're gonna get, but I thought
I hope not too much. I think we played it safe.
I thought we were kind of neutral today. You know what? You try to be objective, but sometimes you don't, right?
I know.
Sometimes it is what it is.
Thank you so much, my friend. I really enjoyed this. Thank you.
Yeah, I did too. Yeah, just hang out 1 second. We're gonna end the live, guys. Have a great day. Good night. We'll see you tomorrow.